Shortly after starting your lawsuit against your careless doctor, the defense attorney reaches out to your lawyer and tells you they want to start negotiating. They make a settlement offer that you find to be totally offensive. And you begin to wonder, does it make a difference when a settlement offer is made in comparison to how much they actually offer? You want to know the answer? Come join me near the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. In my experience, the answer is yes, it does make a difference. Now, what do I mean? At the very beginning of your case, the defense is behind the eight ball. They don't have all the facts. They don't have all of your medical records. They don't know the full extent of your injuries yet. All they know is that you started this lawsuit. You have general allegations of negligence and malpractice against this particular doctor. The defense attorney has likely spoken with their client, the doctor, to find out what this thing is all about. And now, what happens then? Now, all of a sudden, you get a call, or your attorney gets a call from the defense attorney who says, listen, we'd like to try and negotiate. We'd like to try and settle this case. And your attorney says, terrific, I'll get back to you with the demand. No matter what demand your attorney makes to the defense, do you think that the defense is going to turn around and say, you know what? We think that's appropriate. We'll give you every single thing you're asking for right now, despite the fact that we don't know what your damages are, despite the fact that we don't really know how badly you were injured, despite the fact that we don't know what limitations and restrictions and disabilities you have, or, importantly, whether or not they will be permanent and lifelong and disabling. We don't know any of that. So now the defense comes back and gives you an offer. They give you an offer of, let's say, $100,000. And you and your attorney immediately reject that. You say your case is worth 10, 15, 20 times as much as that. And now you say, have a nice day. Now, why did the defense try and do this? They do it to try and get a feel for, number one, whether you're interested in trying to negotiate. That's number one. There are some lawyers and law firms who turn around and say, listen, we will not negotiate your case under any circumstance. We want to go to trial. We want a jury to go ahead and evaluate this case. And we want a jury to put a number on the value of your injuries. In that instance, the defense will then know immediately that there is no possibility of trying to settle your case, and they will not engage in settlement negotiations, nor will they make an offer. On the other hand, now that they know that you might be willing to go ahead and negotiate if the number is right, now they have a better understanding, a viewpoint, a mindset of you and your attorney that at the right time, it might be worthwhile to engage in settlement discussions, and for the right amount, might even be able to settle this case prior to trial and eliminate the risk of going to trial and having an unknown verdict. When you go to trial, neither side knows exactly what's going to happen. No side, no attorney can guarantee what will happen at trial because you're dealing with 6 members of the community in New York who are evaluating this case, your medical malpractice case, and they don't know you, they don't know the doctor, they don't know any of the details of your case. And now you're ultimately relying on them to, number one, recognize that what this doctor did was careless. Number two, that recognize that his carelessness caused you harm. And number three, recognize that your injuries are permanent and disabling. You are hoping that they reach that point. And ultimately, if and when they do, they will now be required to compensate you for all of the harms and losses and damages you suffered because of this doctor's wrongdoing. Okay, so now let's say the defense chooses not to engage in settlement discussions at the very beginning, but rather during the course of your lawsuit. You should know something important. These cases involving medical malpractice typically take anywhere from 2 to 3 years from start to finish. So during the course of this litigation, at some point during that time, the defense reaches out and makes an offer to your attorney and says, listen, we've begun to evaluate this case. We think the case has a value of, let's say, $500,000. We'd like to offer you $400,000. This way, it's a discounted amount, and if you're willing to do that, the case is done, over, we both save money on both sides, and now we move along. And so what do you do in that instance? What you do is you have to have a detailed discussion with your attorney about the risks and benefits of either accepting the offer or rejecting the offer. Now, you might be saying, what are the risks of accepting the offer? Well, the risks are that if you were to go ahead and reject the offer, and now you go further down the road in your case, you might get more in terms of a settlement later on. You also run the risk that if you decide to reject the offer and go to trial, there is a possibility that a jury will come back and give you substantially more money. However, that outcome, now you have to recognize that that is fraught with the likelihood that the defense will appeal any such verdict. When the defense makes an offer in the middle of your litigation, are they going to give you full value for your injuries? In all likelihood, no. There's no real incentive for them to do that at that time. Okay, so let's move forward. Let's say you reject all the offers and now your case proceeds to trial. Right before trial, the defense calls your lawyer and says, hey, we'd like to try and settle this. We're now willing to give you $750,000. We think the case at best may be worth $800,000, $900,000. Maybe on the best day in the world, when all the stars are aligned, maybe this case has a value of $1 million. But if you want to settle this right now with a guaranteed amount, we'll give you $750,000. What do you notice? In this scenario, in these hypothetical set of facts that I'm going through with you, in the beginning, the defense wants a substantial discount to try and settle the case early on. During the middle of the case, you might get an offer that is more than what they were originally thinking, assuming they wanted to negotiate early on. As you proceed to trial, now each side is investing their time, effort, resources into getting ready for trial. And they know the costs that are involved with going to trial. They're not worried about spending the additional money on their experts and their attorneys to go ahead and defend the doctor. That's not really a concern. But instead, they come back and say, listen, your case has a certain value, we understand that, but by settling this now, you are guaranteeing a specific amount of money that you can walk away with right now. Are you willing to do that? And in order to answer that question, you have to have a very detailed discussion with your attorney about the risks and benefits of either accepting or rejecting that offer. So why do I share this quick information with you? I share it with you just to open your eyes and help you understand what really happens in these medical malpractice cases in New York. I recognize you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.